Okay. Hello, people, you there?
Afternoon, Thurman. Hello.
Good afternoon, Tanner. How you doing, man?
I'm good there, brother. Good, good. I'll turn my video on in just one moment.
Don't worry about it, man. I'm glad you was able to show.
Yeah, absolutely.
All right, we got a few folks here. They in the background somewhere. Okay, we got Mr. Waters and Teresa. All right, Miss Cooper. All is well, Miss Cooper. All is well.
Good evening, everyone.
All right. Good evening, Mr. Waters. How you doing?
I'm great, thank you. And you?
Good, 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 man. I'm glad you stopped by.
Yeah.
I'll share some information with you guys. Hopefully, you'll come away from this more enlightened about what's being done in your name.
Right. I mean, the title of tonight's presentation really attracted me. Judicial slavery. Yeah.
Yeah, because you know, and when I thought about how to really title it, it's really to me it's about the 13th Amendment. But I think that when we look at the whole context of slavery, chattel slavery, there is, you know, once the 13th Amendment was enacted, you know, I think that the country began to experience folks getting arrested for mediocre crimes in order to, you know, create a labor force.
Right.
So that's why I titled it that way.
Well, great. And well, you know what the 13th Amendment did.
Yeah.
And there's a representative who is submitting legislation to close what he calls the loophole in the 13th Amendment, you know, unless duly convicted of a crime, then we can re-enslave you. So
Yeah.
let's see if under this Biden administration that proposed legislation gets any traction.
Yeah, because it's the private prisons or even the state prisons, man. I mean,
Yeah,
there's a lot going on out there. And, when in my ignorance, a lot of this stuff I can, just give it to you straight. A lot of, some of my issue, I ain't gonna say everybody else, you know, it's like in civil law, it's called contributory negligence. You can contribute to some of the things that can happen to you, but then again, people will take things to warp speed and
exactly.
create an industry out of it.
I remember years ago when I was doing some research, I came across this federal, it wasn't the circuit court, it was a district court, but the case originated out of Arkansas, let's say around 1967. And the people in prison, of course, they were required to work and not be compensated. So they filed a lawsuit, which was certified as a class action lawsuit. And the district court, and I'm just roughly paraphrasing, but the people in prison framed it as a violation of the United States Constitution to force them to work without compensating them. And the district judge basically said, well, you better go back and read the 13th Amendment.
Yeah.
Because the 13th Amendment allows the slavery that you're saying is unconstitutional, and you're making your constitutional argument saying it's a violation of the 13th Amendment. And for me, and this was a real long time ago, but it was a wake-up call for me because one, I knew of the 13th Amendment, I knew the implications of it, but I hadn't seen people in prison challenge it, and then to hear a court say, basically to them, you guys don't understand the law because the 13th Amendment allows this form of slavery.
Oh, no doubt about it. And it does. It says neither slavery or servitude will be within the jurisdictions of the United States.
No, what it says is neither slavery nor involuntary servitude shall exist except as a punishment for a crime, whereas the party shall have been duly convicted shall exist within the United States or any territory subject to the jurisdiction thereof. The key word, there's two key words there. One is except. The moment that you say except, you say you can't have slavery unless it's justice, right? And the second one is duly. Now, the word duly is defined by Black's Law Dictionary as in accordance with proper procedures. The procedures are defined within the Constitution of the United States. It's the duly established procedure, starts with the grand jury, the investigative process, the trial all the way through the final adjudication. And if you don't follow those procedures, then you are not imprisoning or you're not enslaving those people properly. But the problem that I have with the 13th Amendment is it was meant to abolish slavery. And yet we codified slavery as legal within our law. And that is absolutely absurd. The public needs to know that. They need to be aware of that. We are the only industrialized nation in the world that not only permits slavery, but has it codified into our law. And what we boast to the world is completely contrary to our principles and what we believe in. And we need to address that. We absolutely do. Yeah. Thank you. I'm sorry.
Thank you.
Because that's the exception.
We've already begun, huh?
Yeah, no doubt about it. And that's exactly what a judge told me when I told him when I petitioned the court on a state writ habeas corpus, and then I'll take you guys into, but I just want to make this comment. And that's when I thought it was striking, because when I said to the court, prosecutorial misconduct and all the rest of that. So what the court said, you know what? I'm gonna read it to you because I have it here, and then we can get down. This is a part of the a conversation. So I'm a court order slavery issue. So that way you can know exactly, what the 13th Amendment says and how they talk about it in the court. And then we can get into it. Oh, nope. Hold on for 1 second. I'm trying to locate something. Then we can get into our stuff. I just hope let me see, petition for writ of habeas. Well, you know what? I'm not going to waste your time. I'm going to figure out. So thank you guys for coming. And I'm just going to get right into it. I guess the first question or the first observation I should make is an observation of jurisdiction. You know, let me put it to you. On September 19th, 1996, I was arrested. 2 police officers showed up at my place of employment looking for me. They told the employer, this is what they told the employer, because I want to do it with you guys chronologically. So I want to share with you this right here, so that way you can start from there. All right, where's where you guys at? Because I know we. So I'm gonna share with you a letter that my former employer at the time had wrote. Can you guys see that letter?
Yes.
Okay, so this was wrote October 16, 1996. To whom it may concern, I am Loretta Plaskia, controller at Exhibit Corporations of America, located at 4623 Crane Street, Long Island City, New York. I am writing a statement as I remember the events leading to Thurman Brown being escorted from our premises. I had found 2 men in our reception area and inquired as to who they were waiting to see. Our plant manager had already greeted them, Pete Sims. They told me that they were looking for Thurman Brown. They said that he had violated his parole from Tennessee. Now remember that, violated parole from Tennessee. They informed me that they could not disclose why he was on parole because they themselves did not know. They told me that he would find out when they returned to the station. I actually see their ID. They both showed me what appeared to be valid ID. They were detectives. I was assured they would call me with further details. They never did. Thurman Brown was on his lunch break at the time. We informed the shop foreman to have him report to the 5th floor where the reception desk is immediately upon his return. I went back to my office. When I returned approximately 20 minutes later, they were gone. I was told by my staff Thurman came to the 5th floor and they escorted him out. He had only been employed by us a short time. Prior to this incident, we had no problems with Mr. Brown, seemed to work hard, came in on time and got along with other existing crew. I hope this helps with clearing up the details. So when they came and arrested me, they arrested me on the premise that I was a parole violator. They didn't have parole with them, but I was a parole violator. I'd never been to Tennessee before in my life. So, but you know, that's how they came at it. So they came in with a lie. So now I'm going to speak to you, remember that, but I'm going to speak to you guys about jurisdiction. So jurisdiction is a question of a person can hold you for trial. I've been arrested, correct? So now I'm being held for arraignment, so forth and so on. So I'm arraigned on the 20th, the following day. The following day I'm arraigned and, you know, plead not guilty, yada, 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 and assert my rights to appear at the grand jury. So they will process you at that point for indigency to see whether or not you're poor, and you will get an attorney. So you have a right to an attorney. You just have a right to an attorney, a delayed right to an attorney. So it may take 3 or 4 days to get you an attorney, even though the Miranda said you have a right to an attorney. You know, if you can't afford one, one will be given to you. I'm not going to argue that. That's another conversation. But you have a delayed right to counsel because I'm a poor person. So on the 24th of September, I appeared before a grand jury. Now, remember when I said to you, that letter said to you, he was arrested because of parole violation. This surfaced on the 20th. I was arrested for the crimes was for burglary and second degree, all burglaries. So about 5 burglaries, I was arrested for 5 burglaries. no violence, no nothing, just burglarizing homes. So on the 24th, I appeared before the grand jury. And I testified before the grand jury. The detectives testified before the grand jury. I don't know what they said, but I know what I said. So I'm basically saying, hey, I didn't do it. I was at work. These guys came and picked me up at work, and I don't know what's going on. That's basically my story. But the detectives went in there and told them, I believe, told them this story. Because I want you guys to see something. Remember the parole violation for a Tennessee warrant? So I want you to look at this right here. This is an article that appeared. Can you guys see it? September 19th?
Yes.
You guys see the article? So that was the day I was arrested. So they had put, this is a weekly newspaper, so it runs every week, once a week. So they put in the newspaper, suspect sought. Christine Bryceland was the reporter. She's the neighborhood beat person. She published this article in the newspaper. They had a composite sketch of the suspect. This is what they published, and Crime Stoppers became involved. So as a result of this paper, this sketch in the newspaper, people called in and said that was me. So I don't know this at the time. So a week later, they did a follow-up. You see the date, the 25th? September 25th? So it says, tip nails alleged criminal. So I'm gonna start down here. We are very happy and appreciative. I'm starting at like the fourth paragraph because I'm trying to get you somewhere real quick and we don't have a lot of time. We are very happy and appreciated that the local paper extended themselves and put the information in the paper, said First Squad Detective Carl Ray, who along with his partner, Detective Sergeant Benson Larson, were instrumental in tracking down Mr. Brown. This is what Detective Ray said. We are thankful to Crime Stoppers and the callers who reached out. I feel that Crime Stoppers is an effective tool. I'm gonna stop right there. So remember I told you that this was in the newspaper on the 25th? We went to the grand jury on the 24th. So I believe that the detectives went into the grand jury and told them a Crime Stopper story as to probable cause, as to why they arrested me. They said that folks saw a photograph, a composite sketch in the newspaper. They identified the composite sketch as Thurman Brown. As a matter of fact, in this newspaper article, they even gave the sketch my name, my address on Thursday, September 19th, shortly after the composite sketch based on the victim's description appeared in the Baldwin and Robertson Herald. Nassau County Crime Stoppers received anonymous tip that led police to investigate and arrest Thurman Brown, 31 of Stowe Avenue in Baldwin. So you don't see a picture of me in here nowhere. All you see is the sketch. So the person can infer that you're really saying that I'm the person in the sketch. But be that as it may, what's important is the date. One day after the detective testifies at the grand jury, he says this in the newspaper. So when someone gave me this, so when I got a hold of it, I said, wait a minute, because on the 17th, not the 19th, 2 days before I was arrested, the detectives went to a jewelry store. You see it says September 17th? And it says that this guy, Jack Ohad, I was shown photo arrays of 6 photographs. I have positively identified subject number 2, known to me now as Thurman Brown. This is the same person who on this date, that date, and this date pawned assorted jewelry. So I wasn't arrested because of Crime Stoppers, like the detectives had said. You see the story that I'm saying? So the detective said first, he got parole violations in Tennessee. Then they, on the day after the grand jury, they in the newspaper saying that they are thankful to the callers who called in and said that, you know, I was the guy in the composite sketch. But in actuality, 2 days before that, they were in the store with a jewelry dealer saying, hey, this guy identified this guy for selling jewelry to him. And then even with the victim, look at the date, September 17th. So the victim, her name is Robin Cohen. She said, I was shown a photo array of 6 blacks by Detective Ray. I have positively identified photo number 2, now known to me as Thurman Brown, as the person who entered my apartment on 8/19 and robbed me of my ring and necklace. So they knew me as of the 17th. The Crime Stopper story was a lie in order to get an indictment. So when I confronted them with that information, that state-sponsored perjury to get an indictment, you can't do that. I know enough about the law to know that. So what that did was that caused them a problem to where they had to go and purge that information from the record. But it was a fatal flaw because police don't get to lie about things and then get you indicted. So they felt that if they dismissed the indictment against me, they could not go back to another grand jury and get an indictment because they had lied. So they, in New York State, it's called a sealing provision. New York State legislators allow defendants, cases against defendants to be terminated in favor of the accused, and they will seal the record so no one can ever see it again. So I didn't know this, but I'm gonna share this with you. And this is the part about the jurisdiction part. You see this document right here? I know it's kind of fuzzy up on the top. Do you see it? This is a court order. I'm gonna start at the top. You see this Nassau County Police Department. Now this is in 2002. 2002. I'm upstate somewhere. I'm in Green Haven Correctional Facility. So I'm in Green Haven. So I'm trying to get photographs and stuff like that from the police department. So under the Freedom of Information Act. So the police officer, Sheila Wimsey, wrote me. She said, dear Mr. Brown, receipt of your recent correspondence and hereby acknowledge. Enclosed, please find a copy of the sealing order. You should contact Nassau County First Department Court. Nassau County First District Court, 99 Main Street, Hempstead, New York, 11550 for information regarding the judge's name and the sealing order number. We are not in possession of that. So when I got that up in state prison, I'm like, well, what is this? Why come I'm not allowed to get access to my records? Because I didn't know what this meant. So I began to go to the law library to find things out. So this is the order. And what I want you to see about the order is, you see it says Brown Thurman J. Deposition date 10/7/1996. It says date of birth 4/16/1955. My date of birth is 4/16/1965. And then it says female. It doesn't say male. You know what I mean? So they did that adjustment in the order in order to facilitate me not being released. 160.50 says that when things are terminated in favor of the accused, all of the criminal records are sealed and the person is restored back to his place prior to being arrested and prosecuted. So that's what that means. It's an exoneration. But in order for them to purge the records and still have me in custody, what they did was they changed my sex from male to female. They changed my date of birth from 1965 to 1955. So that way, when the court order is disseminated and it hits the sheriff's office, they don't have to release me because they're looking for a female whose date of birth is 1955. But everything else you see on the right side, all of these numbers, they case specific. So it's my case.
Thurman, I have a question.
Go ahead.
Is that your NICID number?
No doubt about it. So everything else, that's why I said that everything else is case specific. So all of the docket numbers that you see, on the middle side it says sealed 160.50, sealed 160.50, and the judge's name and the date that he did it. All of my cases, and you see it even says my indictment number, 9646996, all are sealed and terminated in favor of the accused, but don't nobody tell me. So they make an order. Now 160.50 does this. All of the records that exist, photographs, fingerprints, grand jury testimony, whatever existed at the time that they wrote this right here, it permits them to destroy it or seal it. But in the provision, it says you can destroy it in 160.50 because they got an issue with the grand jury and they need to get at those minutes. So they use this provision, CPL, Criminal Procedure Law 160.50, to seal the records and terminate them in favor of the accused. But because they changed the male to female and the date of birth, it did not have an effect on my release. So I didn't know this document existed. I just knew that they was telling me at the time I couldn't get access to my records. So, you know, some guys in the law library in the state prison, they told me what it meant, or I was able to find out. So this is what I want you to see. It's by operation of law. That's what 160.50 does this. It seals the records and terminates them in favor of the accused. So what happens then is once this order is issued out by the district court clerk, it has to go to all law enforcement. So what law enforcement does is they send it out to every agency. And every agency has to document the fact that you cannot let an employer or anybody else look at his records. His records are sealed. So I want to show you by operation of law how that works. So I'm going to share with you.
Have you considered, Thurman, the full faith and credit provision? I mean, because I'm concerned a little bit about just the alteration of the document. I mean, that is a criminal act. You know, technically, that document should have been removed completely, and that does violate the full faith and credit provision. I mean, we got to rely upon the state's document for the accuracy, and there's no accuracy in that document. If you go ahead.
So what I'm saying to you, Tanner, you know, you're absolutely right. So what I'm saying is there's a presumption of regularity. I'm using that. The presumption of regularity, that all things that happen inside of a criminal proceedings, there is a presumption that they are correct. So if there is a 160.50 decision, there is an assumption of regularity that attaches to it that you can't go back and revisit. You can't say, oh, this never happened, because the presumption of regularity knocks that out the box.
Right. Now, obviously, the reason why they want to keep it is they want that particular criminal element to remain so that they can keep it in custody. But by altering the document itself, that's violating the full faith and credit, element of the Constitution. So, it's not an accurate document. It's not an accurate record, but it keeps you in custody because it maintains that particular criminal adjudication.
The sheriff is not bound by it. The guy who's holding me in custody is not bounded by it. So what the 160.50 provision does is now it has to be sent out to all the law enforcement agencies. So this is my rap sheet, New York State Division of Criminal Services. So on page 3, all of the cases that I'm charged with, I'm gonna just go right to them because I done highlighted them. You know, I do got a criminal history. It is what it is. Arraignment on the 20th. Case number 29226. It says on September 5th, 2005. That's when they recorded it, but it was sealed upon termination in favor of the accused, 160.50. Case number 29222, sealed upon termination of criminal action in favor of the accused. 223, sealed upon termination of criminal action in favor of the accused. 2224, sealed upon termination of criminal action in favor of the accused. Indictment number 9646996, terminated in favor of the accused. The next thing it says, convicted upon verdict. So how do you go from all of these things being sealed and terminated in favor of accused to a verdict? What other grand jury process or docket numbers are valid? Where did you who told you to re-prosecute me? See, I don't know this stuff at the time, but the fact of the matter is, what we're looking at is all of these criminal actions are terminated in favor of the accused. So now what is taking place is a charade. And what I mean by charade is, if you don't have subject matter and personal jurisdiction over a person, if your stuff is terminated in favor of the accused and you continue to prosecute the person, there is a thing in our criminal law called double jeopardy. You can't prosecute a person for the same crime. So is there a provision in the law that says someone could re-prosecute? I don't think so. So they didn't have no permission from no court to re-prosecute me on the same docket indictment number that are considered a nullity. If you are, hold on, this person keeps calling me up. Thurman speaking. Yeah, that's Congresswoman. So what I'm saying is now we have a process. We have a invalid process that has the full weight of the law proceeding through the judicial system. So what we're talking about is pretrial hearings, pretrial decision, voir dire, picking a jury, having a trial, having a verdict, being judged. All of those things are charades. They're sham. Because the original cases have been terminated in favor of the accused. So now you have the appeal process. You have an appeal decision. You have an appeal to that decision, all to the New York State Court of Appeals, the highest court. Everything is denied in warp speed. And then you have, I didn't do a federal writ. I went straight to the United States Supreme Court. So this is the decision that the United States Supreme Court, I want to show you the document so that way you can actually say you saw the document. Because, I mean, these people are incredible.
Well, you know, there's the element of the rule of law, like what I'm dealing with the Fifth Amendment being absent within the state of Washington and the other states. You know, they could rely upon, at least at the federal level, they would rely upon Hurtado versus California from 1887 that says that the indictment's not required. Mm-hmm. And you know, so if there were irregularities in the relying upon the indictment from the grand jury, if it's invalid and they want to proceed, they would just rely upon that judge-made ruling that violates the Constitution clearly. But they proceed anyway. You know, I think that there could be a key in that you might need to think about with Hurtado.
Now, you see this document right here? This is the decision of the United States Supreme Court. So when I say that the United States Supreme Court has created binding precedent, what I mean is this. Under the 13th Amendment, neither slavery or servitude shall be permitted within the United States unless and until a person is duly convicted of a crime. I'm saying that when my cases have been terminated in favor of the accused, I'm not duly convicted of any crime. So here is a question. Did the lower court perpetrate fraud upon the higher court? Is this a pattern in practice? Are they doing this in New York State when they find difficult cases? Are they using the 160.50 provision to seal cases and terminate them and then continue to re-prosecute men, poor guys or rich guys, whatever, people who don't know this is taking place? How many people in the system have that kind of situation? And does the higher court know that? Because the higher court, on a record that's void of subject matter and personal jurisdiction, said this: on the petition for writ of certiorari to the Appellate Division, Supreme Court of New York, Second Judicial Department, number 9711757, on consideration of the petition for writ of certiorari herein to the Appellate Division, Supreme Court of New York, Second Judicial Department, it is ordered by this court that said petition be and hereby is denied. October 4th, 1996. So I'm saying that when the United States in Thurman Brown versus New York said denied, I'm saying that that decision, when the court didn't have jurisdiction, whether the court knew things had happened at the lower court level that they was terminated in favor of the accused, I'm not here to argue that. They're gonna have to bicker about that amongst themselves.
So, Thurman, I have a couple of questions.
Go ahead.
So, I mean, clearly I saw that they sealed all of those cases because there were a number of burglaries that they alleged that you had committed. Did the case go back to the grand jury and then
Nope.
the grand jury voted an indictment?
No, they
How the
proceeded.
hell you end up in a...
They proceeded. They re-prosecuted on, that's the point. The point I'm making, brother Waters, you got it.
So
right there.
All of those cases were dismissed.
No.
I mean, all of those cases were sealed.
In favor of the accused and terminated.
Right, they were all sealed because it was, determination was in your favor.
Correct.
But one of those cases is the basis of your conviction?
All of those cases. All of them.
Jesus Christ. So what issues did you raise on direct appeal at the appellate level?
So here's the thing, Mr. Waters. Remember, all of this stuff is unbeknownst to me, so I'm fighting like this is all legitimate stuff.
Okay,
So
I know, but what issues did you raise on direct appeal?
Probable cause, the decisions on the hearing, whether or not the sentence was excessive. Those were all the different. It was like 5 or 6 different issues.
Okay.
But what I'm saying to you, Mr. Waters, is it was still a sham because all of those cases was terminated. They had no legal authority to re-prosecute me on top of the same. You know what? Let me read to you what 160. I'm gonna read to you what the law says.
No, I'm familiar with 160.55 of the criminal procedure.
But what about 160.50? I mean, 160.60.
Yeah, I am. But you can read it.
Okay.
But my other question is, did the Court of Appeals deny leave to appeal?
No, leave to appeal on the.
Did the Court of Appeals hear your case? I mean, not the Court of, the Court of Appeals.
Yeah, New York State Court of Appeals heard it and denied it. Yeah.
Oh, they did hear it though?
Yeah, they heard the briefs that was presented because, like I say, we are thinking that all of this stuff is above board.
No opinion? Did they give an opinion?
Yeah, they gave an opinion. They just said everything was done proper. I'm just giving you the shortcut route, but that's basically it. But what I'm saying to you, brother, is this. Just hear me out, because I want you to follow me. Those things, a matter of fact, you know what, I'm gonna read it to you, and then you guys see 150.50.
160.50, yes.
I'm gonna go to 160.60. I want to give you the effect of 150.60, okay? One more. Now, the effect of 160.50 is this. Upon the termination of a criminal action or proceedings against a person in favor of such person, as defined in subdivision 2 of section 160.50 of this chapter, the arrest and the prosecution shall be deemed a nullity, and the accused shall be restored in contemplation of law to the status he occupied before arrest and prosecution. The arrest or prosecution shall not operate as a disqualification of any person so accused to pursue or engage in any lawful activity, occupation, profession, or calling, except where specifically required or permitted by statute or upon specific authorization of a superior court. No such person shall be required to divulge information pertaining to the arrest or prosecution, because it's supposed to be dead. It's a nullity. It's an acquittal. But instead of them restoring me back to my job and releasing me back to my life, they continue to prosecute me on the same docket numbers, on the same indictments that by operation of law are a nullity. So when you continue those prosecutions through the judicial systems, they are proceedings that lack subject matter or personal jurisdiction.
They lack personal jurisdiction,
Yeah.
Thurman. They absolutely do. And that's the litigation that I'm dealing with, is that Article 3, Section 2 of the Constitution it's clear. It says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. That places the exclusive duty upon the Supreme Court to act as a buffer between the people and the state when the state chooses to become a party in the cause. So the reality is that case, Thurman Brown versus New York is identified as the party. And as a result, the duty is on the Supreme Court. For them to deny it actually results in the right that you had violated, because rights always derive from those duties to act. When the duties defined constitutionally within the statute, then duties that are defined affirmatively and applied statutorily are not discretionary. They didn't have the right to be able to deny it. They lacked personal jurisdiction. So what it's worth.
I want to show you guys something. Mr. Waters, well, all of you guys really, but I was referring to you. Now here's Detective Carver. Now when I want to show you another thing about grand jury members. So when I confront them with the state-sponsored perjury, this is grand jury from the 24th. Remember I told you the 24th? Well, when they gave me this detective's testimony in the sham of a trial that we're going through, they gave them to me in out of numerical sequence duplication. So from pages 61 through 78, 18 pages. Through pages 213 to 230, they appear to be duplicate, but out of numerical sequence. But I go line for line, word for word, dot for dot, question for question. I go through everything. So you see this is page 61. You see the first line that says the next witness will be Detective Carray. So on the duplicate, out of numerical sequence, 213, the next witness will be Detective Carray. It appears to be duplicate. You follow me? But in out of numerical sequence. But I want to show you.
Go back up to the previous page.
What line you want to?
Well, no, I just wanted to, it's the same date, 9/24/96. Okay.
No doubt. So out of numerical sequence. I'm gonna show you something though. So on page 213, same testimony. On page 62, let's go to line 15. Mr. Thurman Jerome Brown, On page 214 is duplicate. 15, Thurman Brown. So, but now we're getting ready to see something different. You see on page 63, you see how I got this highlighted on line 7? Thurman Brown on that date is a question mark, correct? And on line 25, lived on 20 Wendell Street in Hempstead, it has a period. So when you go on to the duplicate out of numerical sequence, page on 215, Jerome Brown on that date, it has a period. Then you go down to the bottom, 25 lived at 20 Wendell Street, Hempstead, there's no comma there. So what I'm pointing out to you that there's 18 different stenographical errors that's not identical. So what that means is someone retyped the transcripts and made errors and played them off like they were duplicates. So what I'm saying to you is my assertion that all of this stemmed from them telling lies inside the grand jury and me representing myself. You give me fake transcripts that's an out of numerical sequence duplication in order to hide the fact that you went inside of the grand jury and you told them that I was arrested because of Crime Stoppers, and all of that was a fabricated lie. And as a result, you terminated all of these criminal proceedings because they had fatal flaws in them, and you continued to prosecute on top of that. And though in this prosecution, this is where it gets to the high court, goes all the way up to the United States Supreme Court. So the argument in front of the United States Supreme Court, it frames out this way. There is some conversation as to whether or not a writ of certiorari is anything other than discretion. So I'm saying, hey, I don't have a problem with the United States Supreme Court having discretion over what cases they want to hear. I ain't got an issue with that. The only problem I have is they don't have discretion to hear cases that lack subject matter and personal jurisdiction. You can't rule on a case that's not before the court, legitimately. So what I'm saying that when they ruled in Thurman Brown versus New York to deny certiorari, that had a ramification, that had an impact, and it created binding precedent because it goes back to the 13th Amendment. The 13th Amendment is intimately bound to incarceration. And the only way that a person can be subjected to work camps in state prisons or incarceration is that the person has to be duly convicted of a crime. So in my case, I'm saying my instances were all terminated in my favor. They are nullities. They don't supposed to operate to disadvantage me. So how are you going to deny certiorari on these cases? They didn't know, it's obvious, but that's not my argument. But the fact of the matter is the ramification of their decision, it has that impact. And it creates, I think, binding precedent. Because now a person no longer has to be duly convicted of a crime in order to be subjected to, you know, a prison and workforce labor inside of prison, because I wasn't.
Thurman, if I could, so this goes back to the convict leasing. You know, we're talking about the Wade administration here, and so that's when the whole plea bargain argument came in. That's where the removal of the grand jury, the very first step, came into play. So you know, we have a long history of exactly what you're talking about, dating back to the late 1800s. That originated from the convict leasing issue. The convict leasing issue came from the slavery issue. You know, because once they removed slavery and abolished it as a form of private practice, they just simply transferred it into state practice, but they applied it the same way. And so then the state just simply took over the responsibility of arresting them arbitrarily and placing them into for-profit industries and putting them out to work. It's the exact same thing that's happening today, and It follows the same process as back then. It is the duly established procedures, but they removed that duly established procedure with the Hurtado versus California in 1887. They said, you don't have to have a grand jury. It's not required. It's not part of the due process, right? And that decision was made, and there's still 8 states that do not have a grand jury. And as a result, those 8 states have got thousands, hundreds of thousands of prisoners sitting in prison right now that did not follow the proper procedures to put them there. There's no denying it. No denying it at all. And that's what my case is arguing. And you're absolutely right. They did not follow the duly prescribed procedures. They did not follow the process that's necessary to put you into a slave category. They didn't. And you know, but the court has to step up. It has to take responsibility of the situation. And it doesn't want to do it because it doesn't want to go back to 1887 and say all of the fruit that derives from that act from Chief Justice Waite, that we ought to remove all that. But all of those cases that derive from that, you know, it's all tainted by the illegality of the way in which it was obtained. You know, Taney and Waite, those decisions that they had going back to Dred Scott, going all the way back to Barron versus Baltimore, when they said that the Bill of Rights doesn't apply to the states. I mean, that is a terrible, terrible decision. But today's jurisprudence is absolutely built upon the belief that blacks are not, and were not intended to be included in the word citizen in the Constitution. Blacks are so far inferior that they have no rights which the white man is bound to respect, and slaves are private property protected by the Constitution. So that's today's jurisprudence is based upon that, because the court never went back and addressed those illegal and unconstitutional decisions from Taney and Waite. We have to do that. That's
Period. Right. I've been saying that too. Even more so recently, I've went back to read the Dred Scott decision, and our criminal legal system is, at least as it relates to people of color, is based on that philosophy, not law, but the philosophy articulated in Dred Scott by Chief Judge Taney. So I have a question, and this would blow my mind.
I'm transparent, actually.
Let me just ask this question, right? I saw at least 2 judges that sailed those cases.
Yeah.
Was the trial judge one of those 2 judges that actually sailed the conviction?
Judge Ord. You got Judge DeVizzi and Judge Ord. Judge Ord is the trial judge.
Jesus. And he sealed some of those.
They was all in what I'm trying to say to you was they was all running together.
No. I know they all are in cahoots, but sometimes they have a little more subtlety.
No, but the thing is, when you are charged with burglarizing affluent white people, or white, especially white women, and you over-identify. His wife was in court when I was going to trial. I said to because I represented myself, and I was representing myself because of the indignation and the anger that I felt about how you treat me. You're going to give this person in this composite sketch my name and my address as if I'm this person, and then you're going to try to do me any kind of way. So I'm fighting against you because of just, you know, because how you doing me. I know what racism is. You understand me? I don't know nothing about this seal order and all the rest of that stuff. I'm fighting you because I feel like you're not treating me fair. You understand me? So when the person was in the courtroom just hanging out and everybody else was gone, I was like, well, who is this person? To the legal advisor, Claudia Shorts. And she said, well, people can be in the courtroom. I said, no, people can't be in the courtroom when there's nobody else in here but me. You understand me? She said, well, that's Judge Ort's wife. And when I looked at her, she looked at just like the one of the victims who had took the stand. So she stood behind me, and I turned around and I said, Miss Ort, because I had the duplicated transcripts. You see, I'm fighting that way because how you gonna, you know, tell me I'm getting a fair trial when you're sabotaging me with fake transcripts? So when I turned around to her, I said, listen, you need to talk to him. Because I know he realized what he's doing. And she just like, you know, put her shoulders up in the air and like, well, what can I do? You know what I mean? She was caught off guard. You understand me? But what I'm saying to you is that, but Judge Ort is the same person who, Judge Ort and Judge DeVizzi. Let me pick it back up because you saw exactly correct, Mr. Waters. You saw exactly correct. So I want to share that document again because you got good eyes. So the seal order, you see it's by Judge Ort, but you have another guy's name, Judge DeRiggi.
Right.
Donald D. DeRiggi. He was the judge who I did habeas corpus with, a state habeas corpus. And what I said to him in the habeas corpus was all of these different things were taking place. And he said, look, I'm not going to deal with that. It said, as a matter of fact, the judge have already looked at the grand jury minutes and found them to be sufficient. So I'm not going to deal with that issue. And as far as the prosecutorial misconduct, that can be all dealt with in the pretrial hearings. So, but I didn't know, like I said, that he had terminated one of the docket numbers in my favor as well, because all of these docket numbers that you see right here are terminated in my favor. As a matter of fact, I'm going to show you my verdict sheet. So that way you can see that the docket numbers go from 29226 all the way to, go from 29222 all the way to 29226, 96. And the indictment number is 96469 at the bottom here. So on one of these documents here, we will have, let me see, it might be this one. No, it's not this one. SCOTUS. Let me see, counterfeit transcripts, court order. Okay, no, here go one of the decision, the state court decision about the slavery issue. It says, okay, appeal from a judgment of the Supreme Court entered on June 27th, 2001 in Clinton County. I was in Clinton Correctional Facility. Okay, let me get through all that. Petitioner is incarcerated as a result of his convictions of a number of crimes in Supreme Court, Nassau County, People versus Brown, yada, yada, yada. Based upon claims that the trial court was deprived of jurisdiction over the criminal actions as a result of fraud and or other misconduct perpetrated by the prosecutor, the court, and virtually every other person who was even remotely involved. Petitioner files an application for writ of habeas corpus, concluding that the verification of the petition required CPL R7002C was lacking at that. In any event, the petition failed to state a claim that was appropriate for habeas corpus relief. Supreme Court denied the application for a writ. Petitioner appealed. Now, here's their synopsis. Assuming that the lack of verification could be ignored, we agree with the Supreme Court that the petition failed to state a claim that is appropriate for habeas corpus relief. Petitioner's argument that the Supreme Court misconstrued the nature of his claim is unavailing. According to petitioner, his incarceration as a result of a criminal action over him, which the trial court lost jurisdiction through fraud and or other misconduct, is a form of slavery in violation of the 13th Amendment. Thus, petitioner claimed that habeas corpus is an appropriate remedy to release him from the bonds of this slavery. Petitioner arguments overlooks the exception in the 13th Amendment for punishment for crimes whereupon the party shall have been duly convicted. In this case, there is a judgment of conviction, which, despite petitioner's claims to the contrary, is valid and will remain unless and until it is reversed or vacated. Accordingly, petitioner currently has no 13th Amendment claim, and his underlying claims of lack of jurisdiction, fraud, and misconduct represents direct attacks on the validity of the judgment of conviction, which could have been raised on petitioner's appeal from that judgment or by way of post motion, yada, yada, yada. So they raised the fact that there is an exception in the 13th Amendment that permits slavery, but the person has to be duly convicted of a crime. See, I didn't have the information of the the seals that these cases were terminated in my favor when I argued that what I was arguing with this court is the fake transcripts, the fake grand jury transcripts. Because I'm saying when you tamper with grand jury transcripts, they're null and void. There is no accusatory instrument. How you doing, Sean?
What's happening, my brother? How you feeling, man?
Well, we chopping it up, just talking about it. Glad you were able to join us, man.
Yes, sir. Yes, sir.
So, are you guys seeing this a seal order?
Yeah, I see it.
So, despite the fact that, so when I went to the Supreme Court on the certiorari, Tanner, see, this is what the interesting part is. I told the Supreme Court that they was fabricating or counterfeiting grand jury transcripts.
Right.
So the Supreme Court, like I said, I don't know nothing about this stuff right here. This is all unbeknownst to me. So, but when I'm going to the Supreme Court, I'm taking them fake transcripts that I showed you guys, the duplicates. I'm saying to the Supreme Court, listen, you can't make a decision on this certiorari, even though it is my legitimate process in the judicial process. But what I'm saying to them is, I need for you to tell the state court that you are sending this record back down to them to reconstruct the grand jury minutes and settle them, so that way I won't be denied my right to petition the government for redress of grievance. So instead of the Supreme Court abstaining from any decision in my case and sending the record back down, because a writ of certiorari is a review of the entire record. So you're giving me lip service if I'm handing you duplicate transcripts and you don't have those transcripts settled. You're giving me lip service when you say you are actually considering my petition, because the portion of records that I just gave to you has an irregularity in it. So you need to help me out here and send it back down there and make them give me a hearing. But instead,
Right. And so,
go ahead, Tanner.
well, so, you mentioned the writ of habeas corpus, and the thing that bothers me is that we have failed to recognize or remember the purpose of the writ of habeas corpus. It is specifically intended to challenge the validity of the detainment, which would have to do with that grand jury indictment. That's exactly what that's about. So when you raise that issue within the writ of habeas corpus, it should have been addressed within that writ. But the court seems to think that the writ of habeas corpus is nothing more than an appeal, right? And that's how they treat it. So they don't. I think that goes back to the Judicial Act 1925. I think that they just kind of changed, a lot of different things, and so they treat the writ of habeas corpus as though it's an appeal, and that's not what it's for. It's to challenge the validity of the detainment, and the validity of the detainment would derive directly from your grand jury indictment that is not valid.
I'm gonna make this observation, Tanner, and it is what it is. I think something more insidious is taking place, because
Absolutely,
he ridiculed me. He said, this guy has made allegations against the prosecutor and everybody that was remotely involved in this case. So he was talking down on me in that decision. He was saying to me that you saying, virtually everyone who even had a remote involvement in your what's called is in some kind of conspiracy. You know what I mean? So what he basically said to me was, hey, unless and until you get this thing reversed, you ain't got no slavery issue, because you failed to realize that there is an exception in the 13th Amendment that says we can subject you to whatever it is that we're subjecting you to, because you stand duly convicted of a crime. But in actuality, I don't, because this seal order says all of my criminal proceedings were terminated against me in my favor and sealed. And to this day, they are still sealed. So how am I then convicted of? As a matter of fact, there is another order. Did you guys get to read the court order in the event by Judge by the district court judge, Ross. Well, I'm gonna read Judge Ross, yeah. And this will give you a better look at it, Mr. Waters. What's on your mind, man?
Go on.
You ever heard anything like this before?
I saw Rehnquist's name there.
Yeah. I'm getting ready to bring it out to you. I sued the Supreme Court, the Rehnquist court. I mean, Ruth Bader Ginsburg and all of them. Everybody who had a part in that decision, I sued them. And they were protected under the doctrine of collateral estoppel. In other words, with the grand jury minutes, they said that the court had already made a decision on it, that I had got the same thing twice, and there was no basis for me to allege a Rosario violation. But the court didn't give me a hearing. That was an ex parte decision. But that's neither here nor there. But Judge, so I took him to court, Eastern District. So this is District Court Judge Ross. I'm gonna skip through the preliminary stuff, and I'm gonna jump right into the meat of the thing. So I'm gonna start right here. Matter of fact, I'll start right. Plaintiff alleges several violations of his constitutional rights under Section 1983 in connection with his conviction on various theft offenses in 1997. C. Brown versus United States Chief Justice Rehnquist. Plaintiff action, well, I'm gonna just skip out that. But those are all of the cases that are against them. So plaintiff now brings this motion for reconsideration pursuant to Rule 60.
Hello, Mr. Brown.
Yeah.
This is Anika Cooper. I'm so sorry to interrupt, but I have class, and I wanted to know if because you're recording, would you be able to send me the recording? Because I really want to finish this, but I still have class, and I don't want to miss it.
I got you, Anika. Don't be late to class. Have a great night. I hope we wasn't talking in circles. Did you understand any of this stuff?
Yes, I understood. I'm a criminal justice major. That's one of the main reasons why I decided to come and join. I felt it was really interesting, and I wish I could stay, but I have classes. So can you please send me the recording, please?
I got you. So I have to find. I hope that your email is on your LinkedIn, but I had put up on the LinkedIn. If any of you guys wanted any of this stuff, just email me and I'll send it to you. I'll give you this stuff. It ain't no big thing. Matter of fact, you should be talking to your professor about trying to get me up in there. Matter of fact, you should share this with them.
Yes, definitely. That's actually what I wanted to ask you, because I'm the president of the Criminal Justice Club at Monroe College. So it'll be very, very nice if me and you could link up, connect with each other, so that way you can talk to them about, the situation and everything, because it will be very, very informative for them.
Yeah, it would be a way to look inside the criminal justice system. I got you, Ms. Cooper. So go on to school, and I'll catch up with you later.
Thank you so much, Mr. Brown. I'll see you later. Later, guys.
All right. So plaintiff now brings this motion, Rule 60 of the Federal Rules of Civil Procedure, alleging that the judgment rendered against him is void on its face because the court lacked jurisdiction over the parties, jurisdiction over the subject matter, or jurisdiction to render the judgment. Specifically, plaintiff alleges that because certain New York State criminal actions were terminated in favor of the accused pursuant to NYCPL section 160.50, IDA 2, the judgment rendered against him in this action is void. To substantiate his claim, plaintiff has attached to his motion documents which show that a number of state indictments against him were dismissed in October of 1996, CID at 3-4. The discussion, as indicated, plaintiff alleges that the judgments rendered against him must be vacated pursuant to Federal Rule Civil Procedure 60B4 because such judgment is void on its face. It is established that the standard for granting a motion for Rule 60 is strict and reconsideration will generally be denied unless the moving party can point to controlling decision or data that courts overlook. Matters, in other words, that might reasonably be expected to alter the conclusion reached by the court. And it goes through all of these criminal justice things, those are all cases. But here's the important part. In the instant submission, and I'll give this to you guys if you want it. In the instant submission, the instant submission does not state a basis for reconsideration. It does not suggest any point of law or fact which this court might have overlooked. On the contrary, the plaintiff in his motion admits that this court and defendants were aware that the relevant criminal actions were terminated in favor of the accused. Moreover, the indictments which plaintiff asserts were dismissed could not have been the basis for his 1997 state court conviction, which was the underlying subject of the instant Section 1983 action. As indicated, plaintiff submitted evidence that several New York State indictments against him were dismissed pursuant to NYC, New York Criminal Procedure Law 160.50. These submissions, here's what she's saying. These submissions indicate that those indictments were indeed dismissed October of 1996 IB, and thus could not have formed the basis of his convictions in 1997. Therefore, the factual basis of plaintiff's motion is wholly irrelevant to the judgment that he seeks to consider. But the one thing she didn't talk about is what did form the basis of my 1997 convictions. So I took her to the Judiciary Committee because I'm saying you cannot make a statement once jurisdiction has been invoked. You cannot use an assumption to make to form the basis of a decision.
Hold on. But you're arguing that your conviction is based on
the 1996
these indictments that were indeed dismissed, right?
Exactly. But what she said, listen to me now, what she said was the 1990s, and she admits that those indictments were in fact dismissed.
Right.
And she goes further to say, and could not have formed the basis of his conviction in 1997. So if it didn't form the basis of my conviction in 1997, what did?
No, and if it did, then you have a cause of action.
No, exactly. So I'm saying, what other grand jury is there?
Well, you know, in studying the law that they do a lot of double talking.
But you see this? I use this right here in order to get back in the court. Because what I said to the Eastern District in the lawsuits, I said that all my lawsuits and all my criminal actions, you can't send me back into the criminal court because this is not a criminal court matter anymore. My cases were terminated against me in favor of the accused. So this is no longer a criminal matter. This is a federal matter. You understand me? Because I was incarcerated without subject matter and personal jurisdiction. So you have to look at my case differently. So I put that back in front of the court about 9 months ago, and it's like mum's the word. So all I'm saying to them is, no, you have a federal court judge that said these things were dismissed. But what the federal court judge didn't say was what was the basis for my 1997 convictions. That's the problem that they have now, because what I'm saying to the court is all of these folks who have presented themselves in these lawsuits and in these criminal matters, they have perpetrated fraud because they have been pushing forward stuff that's not factual. And some of them even knew it, because even the judge said in this decision, the court and the defendants were aware that the relevant criminal actions were terminated in favor of the accused. So she knew that I said, hey, you guys knew that these things was terminated in my favor, and you continue to deny me my due process, deny me my rights to redress when you knew it, because these seal orders are a part of the unified court system's records. These documents are a part of the judicial process. So how come you can say that you don't know? And that's the big thing, because I'm saying, hey, you know, it's one thing to be in the Supreme Court on high. You ain't got access to nobody's file, no drawers. You understand me? But you still, just like you tell us, you know, you knew, or you should have known, because it's your process.
One point that I'd like to make real quick. So, you know, once again, I state that a lot of our jurisprudence today derives from these rulings in the past. And if we go to Dred Scott in particular, Dred Scott, the whole issue was that they didn't want to open up Pandora's box to release slaves. That's what it was all about. I mean, they wanted to figure out some way to prevent this person, you know, Dred Scott, from being able to be free. They had to make the decision that he was free. They did have subject matter jurisdiction, so the only option that they had was to remove the individual's right to be able to bring the case into federal court. So the same thing is happening to you right now. Right now, it's driving from that. They don't want to open up Pandora's box, because as soon as they release a slave, it's going to open it up for other slaves to be released. It's the same decision. They're trying to find some way to procedurally keep the slave from freeing himself. Once one of these slaves is free, it's gonna go wild. It's lots of people.
What I'm saying to them is, I don't think you're gonna be able to do me like you did Dred Scott, because Dred Scott master took him into another territory that was free. And then, but check it out though.
Yep.
There was a back and forth thing. So Dred Scott got smart and said, hey, you know, once you took me over into this territory, this is free territory. So he sued for his freedom. You understand me? But the court said that he sued and said, yeah, you're a free man. In this,
right.
I mean, in this, hold on, I got you, Ted. I'm coming right back to you.
Okay.
Because I want to make a point that you're a free man. But when Dred Scott got back to his place of origin and he sued, they said, nah, you understand me? Right. Slaves don't have no right. So his stuff went all the way to the Supreme Court. And the Supreme Court, this is the really important part of Dred Scott. The Supreme Court actually nullified the Missouri Compromise and made all of the states back slaveholding states. So I'm saying, in my case, in the Supreme Court instance, the court is saying you don't have no rights that we have to respect. But what I'm saying to you, you're going to respect them, or you have repealed the right to due process. So
my point is that ultimately the outcome was the Supreme Court didn't want to make the decision, so they sent it back and they said, you are property of the state, go argue with the state with it. In your case, they said to you, we don't want to deal with this, you're property of the state, go back and argue with the state. It's the same argument. It's the same thing. It's happened again.
That's why
exactly. It's the same thing. And it's really, I mean, we cite this law, but we're talking about a philosophy that undergirds the law. We're not going to respect you. We don't even see you as human. You have no rights. And people forget this part, right? But it's really, you have no rights that white people are bound to respect.
Exactly. And that's the point.
And so the other thing is that when you consider the slavery issue, and forgive me, I don't want anybody to take offense to this, but slavery, the roots of slavery have always been primarily economic. You know, in history, all through history, if you couldn't settle a debt, then you could sell yourself into slavery and you could work the debt off. It was a feasible alternative for debt management. It's the same thing today. You incur debt when you choose to violate the law. Once you incur that debt, if you can't pay that debt, then you sell yourself into slavery and you go and you become a slave. And so the thing is that economics affects everybody. That's why we're seeing this mass incarceration right now today. That's affecting a lot more. But it also it is still somewhat race-based, but I don't think it's intentionally race-based. I think that the system is making it race-based because it's it's more of a diversion, right? As long as the races are pitted against each other and they think that this is a race-based issue, we're not looking at the real problem. The real problem is that it's economics, and economics is government. And so the government doesn't want us to address this problem, and we can't address the problem with slavery because we believe that it's proliferated based upon something else, a lie that we've been told. And we need to overcome that lie. And we need to say, this is the basis of slavery. And unfortunately, a certain race was very much impacted by it, but that still was an economic based issue. And today, when you see such a large, a portion of the population of prisoners being of a specific race, it still is an economic issue because unfortunately those people have never been given the opportunity to be able to excel and to have a better life. So they are held in this state of perpetual poverty that still is race-based, and it's still proportional to that economic issue. It's really sad what the system's doing. It's horrible. Right. It's disgusting.
It's all tied together where
exactly
it's economics, but so much of it is race-based and it's tied up in that. And also, I think most importantly, theories of white supremacy, and white supremacy doesn't stand on its own. It must state that there's Black inferiority, where white supremacy doesn't just say, I'm superior, period.
Right.
It has to say, I'm superior and you are inferior. But I just wanted to make a point about the economics of slavery. You had a historian who did a comparative study of slavery in Cuba and slavery in Virginia. And it got to a point, especially with the Industrial Revolution, that machines can do it, could do the work that men and women were doing faster and more economically feasible. And Cuba and the European nations did away with slavery as we know it before America did. So in this comparison in slavery in Cuba and slavery in Virginia, this particular scholar demonstrates that there came a point where it really wasn't economically feasible or profitable in Virginia, but it was so tied in with Southern culture that it had become a way of life. And even when the return on investment wasn't what it should have been, or we could have got a greater return on our investment by fully embracing the Industrial Revolution and industrialization, because it was so tied in with the Southern way of life and ideas of white supremacy, the economics be damned. So they cared about, of course, the return on investment, but their return on investment was not as much as it could have been because they wanted to hold on to, and I have this in air quotations, an inferior way of doing business because it was so tied in with theories of white supremacy, and they wanted to keep Black people subservient.
I agree completely. The only thing that I would add is just simply, once the states realized how much money they could make off of this enslavement process, it's not in their best interest to industrialize because they don't have a product. So, if the states want to generate revenue, which they do, like in Washington State, Article 2, Section 27 says that Congress shall provide for the labor of inmates in for-profit industries for the benefit of the state. That's what it says right in the Washington State Constitution.
In Washington State, huh?
Absolutely. It says that you will have for-profit industries. The state has established for-profit industries for the benefit of the state.
That's convict leasing, rewritten.
Exactly. That's all it is. And then the response that I got from the Attorney General for the litigation that I started, the response from the Attorney General of Washington State was the Fifth Amendment doesn't apply to the state of Washington. That is his response to the United States of America, the Attorney General of a state on behalf of the people of a state to the United States of America is, we don't follow the laws of the United States. This is horrible, but they don't do it because the states are making a fortune off of the labor of these inmates in for-profit industries. And it's not in their best interest to industrialize, because if they industrialize, then they have a business, and state's not a business. So they want this cheap labor. They're making billions of dollars off it. And it's a sad fact And you know, statements like that from the Attorney General of Washington just
Right.
it just curls my stomach, because
It
this is my
curls
country,
mine
right?
when you just
And
said
you're
that
destroying
the
my
United
country
States
by refusing.
Constitution doesn't,
Yeah,
the Fifth Amendment doesn't apply
That's-
to Washington State.
You can go out right now and you can read the Attorney General Bob Ferguson. That is his exact statement on behalf of the state of Washington to me when I said that Clause 1 of Amendment 5 must be applied to all of these prisoners that you have imprisoned and working in your factories that are for profit. His response is that provision or that amendment doesn't apply to the state of Washington today, right now. That's what he said.
But what was the if a guy is saying something like that, there is a context. What is he saying? That because they don't have grand juries? Because what is he saying?
Yeah. So what he's saying is that the Hurtado versus California case from 1887 says that the Fifth Amendment, that particular provision, Clause 1 of Amendment 5, doesn't apply to states. You don't have to do it. So they can choose to do it or not choose to do it, which actually now we're dealing with a confederacy versus a union. Are we in fact a union? Because if we are, then that means that the laws of the United States shall apply in their entirety. And that's why we moved from a confederacy into a union. But yeah, I mean, these are all, we got to go to the root cause of this issue. I mean, we got to go to the beginning, and the beginning is that we have a law, and it's a rule of law, and we need to follow that rule of law. And if there's a judge that makes a decision that's contrary to the rule of law, that's not legal. It's not constitutional. Judges don't make the laws, the people do. That is an exclusive duty and responsibility of the people in accordance with Article 1. Judges don't make those decisions. Now, another thing is that when we deal with stare decisis, because you're talking about precedents, these oaths that these judges take, it is with and to the Constitution directly. So the thing is that when you start to argue that stare decisis applies to criminal cases, that's not true. Stare decisis applies to civil cases, and it's always meant to be that way. But when it comes to criminal cases, in order for that judge to have an oath this directly to the United States Constitution, it can't be through the decision of someone else. He can't be dependent upon someone else's judge-made ruling. If that judge-made ruling is contrary to the Constitution, he can't fulfill his oath. That's why stare decisis it wasn't supposed to apply to criminal cases, because it goes away from the rule of law and it becomes arbitrary rule of man. And but there we have it. I mean, this is underlying, historical underpinnings of this issue that we need to address as a nation.
Exactly.
Exactly.
I mean, I want to, because I've been really looking at the definition of Siri decisive, and I was looking at. Can you guys see that? Because I have it up here.
Yeah.
You guys can see it.
Yes.
Okay. Stare decisive, a Latin term for let the decision stand, which refers to precedent. It is a doctrine that requires that judges abide by the prior decision on the same issue, usually only referring to courts in the same jurisdiction and of equal or higher level. So we're talking about Court of Appeals, that kind of same type of status, to abide or adhere to a decision. So stare decisive, that's when I would think about the 13th Amendment. Let the decision stand. We have an amendment that says this is what it is.
Right, and therein lies the problem. The statement that makes with regard to what it is from a legal philosophy, it's saying to that judge, you're not bound to the Constitution of the United States. You're bound to someone else's precedents. That goes against their oath. Their oath is with and to the Constitution. They shall be bound thereby anything in the Constitution or laws of any states to the contrary notwithstanding. So if they're bound to follow someone else's ruling, they're not bound to follow the Constitution of the United States. That's why that legal philosophy is incorrect. It is contrary to the Constitution, because that judge has to be bound to what the Constitution says, not what the errors or flaws of another man is. It puts them in two different directions. It's pitted against each other. It creates the conflict.
Right.
So you have this argument on the court that says, like they say that what's the guy name? They called him a spit constructionalist who died.
Yeah,
that's
Scalia?
Scalia. Yeah, he was a.
So because I'm getting ready to check out.
Yeah, brother. I see I see what you had put down there about Wildcat. Hey, listen, hit me up, man.
Yeah, I want to know, like, what's your next steps? What are you doing?
Oh, well, I'm still in court. This is what
Okay.
I do. This is my pressure campaign.
What court are you in now?
I'm in the Eastern District of New York. My judge's name is Gary Brown, and Gary Brown has took this decision and gave it to a magistrate court to consider. And what I told the magistrate court was this. I said, well, you know, ma'am, you done made 9 decisions in this case already. And all 9 of those decisions we are going to undo. So this is what I'm going to say to you. I would, my first instinct is to say you should recuse yourself, because any decisions that you may make may be made in the interest of undoing your errors. But I said, however, there is this, sense that you may not have known what these folks were doing. And there is a possibility. So I said, in order to really, be fair about it, I'm not going to ask you to recuse yourself, but I would ask you this: you should appoint me an attorney to make sure that it's fair, because now I have presented to you evidence that my convictions were shams, that they were fabricated, that they were a part of a process where these convictions had been terminated in my favor. So you need to decide. I said, first thing you need to do is you need to make a decision as to what my status is, because the defendants are arguing my convictions. And I'm saying to you that that's further fraud on the court. Now that you have prima facie evidence that my convictions have been nullified and that they are a nullity, then you cannot allow them to talk as if my convictions are valid. So you need to make a statement that's plain about what my status is. And she's been thinking about it for the last 6 months, because I ain't heard from her yet.
6 months? Well, I don't know if that's a good sign, but
No. What I'm saying to you is, because they know now that you pushing this conviction ball forward, when I got the documentation now that says that my convictions were terminated in my favor, then that means that you're perpetrating fraud on the court. So I'm hoping that there will be some pause in terms of them continuing to make that argument, because they may have some fear that their license can be in jeopardy.
well, hopefully.
So we're going to, we're going to be arguing different now. We got a little more understanding of the law, and we have the documents that can push them back up off of us. You know what I mean? So we're going to continue. Like I said, I've been arguing this thing since October 7th, 1996. So, it is what it is. And the only way that you get somewhere in this world is that you don't allow people to think that they can get away with something. I mean, even at the price of taking a hit,
Yeah.
or going in prison. I mean, listen,
And
I spent 12 years, 9 months, and 11 days there.
And never stop fighting for justice.
No, you shouldn't. So
Never.
I still continue to do my personal life. I'm suffering from PTSD. I still have dreams about prison and all the rest of that kind of stuff. I mean, I'm still affected by it, but I do believe that, at some point in the near future, I'm going to get justice.
Mm-hmm.
Dred Scott didn't have the tools that we have.
No.
So I'll continue my, my campaign, and I will put them all up on LinkedIn and Facebook and draw them out, because you're going to have to deal with this.
Right.
So I hope I run into you again down the road.
Oh, definitely. What's kind of funny, my office is right down the block from the Eastern District of New York.
Yeah,
from the court.
I'm planning on being down there in a little while to have a conversation with them.
Okay.
Because we got to have a hearing. So we're going to see, now that we have new facts on the table and we got the evidence there that says everything that you did have to be undone. Now we're going to see how much looking down your nose you're going to be doing.
All right. Keep me abreast of what's going on. And if we are anywhere near normal and they actually are letting people in the courtroom, I'm literally right down the block.
I appreciate your support, man. I appreciate you coming in, helping us with the question of really looking at this. I'm glad. I hope it was time well spent.
Yes. Yeah, because I'm actually working on an article with a friend who's a professor at Lincoln University. And we start with the Dred Scott decision because we're saying this entire criminal legal system philosophically is based on thoughts, ideas, and theories from the Dred Scott decision.
Yeah, it's a lot of precedent there. I mean, listen, if I could add a voice to that, listen, man, I'm here because I'm always trying to get the word out on these people because the fact of the matter is just because I didn't go to law school don't mean that they say if you put it in the book, the black man won't find it. I don't believe that because I'll look at those and I'll find it. And if I find it, I'm gonna confront you with it. So now it's a question of, hey, you gonna stand up?
So take care and look for my invitation to that conversation about expungement of criminal records.
No doubt about it, because that would be a good conversation because like I said, I can add something to it because that should be my situation.
Yeah, because we have one prosecutor on the panel, and I think that is the person who's going to push back on automatic expungement. So we need somebody to throw some good questions at her. All right?
No doubt about it. Just hit me up, man. I'll be there.
Take care. Thank you.
All right, brother. Hey, Charles. Anuka Charles. Monique, are you guys there?
I'm here. Hi, Mr. Brown. How you doing?
All right, I see you made it.
Yes, I was able to tune in. It was a very good discussion.
You was able to follow it?
I was able to follow it a little bit. I kind of got lost with, but I didn't come on when you first began. So I kind of tuned into what I can, be a part of.
We had a pretty good discussion. I hope that it wasn't a waste of you guys' time.
Oh no, I would like to get the recording. I know you were telling that other young lady who was at Monroe that you could email her the recording. So I'll shoot you an email so I could get the full recording so I could listen to it.
Oh, no doubt about it. I mean, it's yours. And I would also, if you wanted to, you should get the documents from out of the event or just ask me. I'll give you the documents that, we talked about tonight if you're really, really interested in this issue. And I'm always, like I told her, if you're in front of some people and, you can invite me. I'd definitely come in and give what I got.
Mm-hmm. Definitely. We all need to be basically abreast of the judicial system. All of us, all of the great ones always have to fall into cracks. I was listening because I had a situation like that where I had to go through the expungement and do all of that nature. But the funny thing about it is one of the charges, they were saying that they weren't able to expunge because of the state, what they said, the state jurisdiction, something like that particular charge wasn't able to be expunged.
Yeah, because in the different states have different rules and regulations, and if it didn't if they didn't, basically agree to it, they're not gonna give it to you.
I said that was crazy, and then the crazy part about it, they didn't even have any evidence to back up that charge. Everything was basically dismissed. But yet they definitely did not want to expunge that charge. So I felt like that wasn't fair. The judge eventually said, I can appeal it, but I'm like, if it's going to be sealed, I don't ever want to come back in your courtroom to even have to deal with anything like that.
Yeah, no doubt. And that was the whole thing. I was telling we were talking about tonight. They terminated and sealed all of my things, but still re-prosecuted me on the same things they had sealed and terminated. So, that's
right.
The conversation. So how do you do that?
Exactly. How's that even possible? Yeah. So I definitely want to tune in from the discussion from the beginning And I always reach out to you to LinkedIn, so we will stay in touch.
All right, I got you. So I will definitely get this to you. So as soon as this thing is up and going and I can make it into a file, I'll send it to you.
Sounds good.
All right.
All
yeah,
right.
Night.
You have a good night. Thank you.
Yep.